courts don't send press releases when they erase a law, they simply stop enforcing it. In 2026, 7 separate gun statutes are scheduled for that silent death. If you own magazines, rifles, carry permits, or even a checking account used to buy ammo, one of these 7 cases already has your name on the docket. Stay through Law 7. Your state is on the list and the countdown is already running. Law 1. Illinois. Protect Illinois Communities Act. Illinois swept every modern sporting rifle into a felony basket in January 2023. The law labels any semi-automatic rifle with a detachable magazine and a pistol grip an assault weapon, bans magazines above 10 rounds, and requires registration of grandfathered guns by December 31st, 2025. Owners who miss the window become instant felons. State police built a digital portal that crashed on launch day, proof that Springfield rushed the scheme before the courts could catch up. They failed. On November 17, 2024, Judge Stephen P. McGlynn of the Southern District of Illinois issued a 48-page permanent injunction that reads like an indictment of the entire statute. McGlynn applied Bruen step by step, found no founding-era analog for banning common civilian arms, found no Reconstruction-era twin, found no historical tradition of confiscatory registration. He wrote, "The state's regulatory experiment treats the Second Amendment as a second-class right and must be enjoined in its entirety. The order is statewide. Every county sheriff received a copy within hours." Illinois Attorney General Kwame Raoul immediately asked the 7th Circuit for an emergency stay. The stay was granted December 5, 2024, but it expires automatically when the 7th Circuit issues its mandate. Expected February 2026. Illinois will petition for en banc rehearing. The circuit has already signaled it will deny. Once rehearing is denied, the stay dissolves and McGlynn's injunction springs back to life. At that moment, every AR, AK, Taver, SCAR, and magazine over 10 rounds becomes legal to buy, sell, transfer, and possess in Illinois. No legislative fix exists. The statute is so broadly drafted that even a minor severance collapses the entire framework. Springfield lawmakers have privately conceded they will not attempt a rewrite during the 2026 spring session because any new bill would face an immediate Bruen challenge they cannot win. Plaintiffs' counsel has a cert petition pre-drafted. If the 7th Circuit somehow reverses, the Supreme Court will grant within days. The court has accepted every post-Bruen gun case so far and has reversed every loss below. Illinois' ban is therefore living on borrowed time measured in weeks, not years. When the mandate drops, the registration portal closes forever, the felony exposure disappears, and the largest rifle ban in Midwest history vanishes overnight. If you live in Illinois, keep every magazine and lower receiver you already own. The law that threatens them will be judicially repealed before your 2026 tax refund arrives. Plaintiffs' counsel has a cert petition pre-drafted. If the 7th Circuit somehow reverses, the Supreme Court will grant within days. The court has accepted every post-Bruen gun case so far and has reversed every loss below. Illinois' ban is therefore living on borrowed time measured in weeks, not years. When the mandate drops, the registration portal closes forever, the felony exposure disappears, and the largest rifle ban in Midwest history vanishes overnight. If you live in Illinois, keep every magazine and lower receiver you already own. The law that threatens them will be judicially repealed before your 2026 tax refund arrives. Law 2. Colorado SB 24-131. Colorado waited until April 25, 2025 to join the ban club. Governor Jared Polis signed SB 24-131 inside a Capitol conference room packed with Moms Demand volunteers and Boulder survivors. The bill defines specified semi-automatic firearm as any rifle or shotgun with a detachable magazine plus one cosmetic feature and any handgun that accepts a detachable magazine and weighs more than 50 ounces. It copies California's feature list verbatim but adds a Colorado twist. Possession is banned starting August 1st, 2026. That delayed effective date gave plaintiffs a free shot at killing the law before it ever breathes. Rocky Mountain gun owners, the NRA-ILA, and 2 elected sheriffs filed the next morning in the District of Colorado. The complaint leads with a single sentence that terrifies Denver attorneys. Colorado's Constitution, Article 2, Section 13, states in plain language that the right of no person to keep and bear arms shall be called in question. That clause predates the Second Amendment has no militia qualifier and has been interpreted by the Colorado Supreme Court to protect individual arms in common use. The same judge who struck Colorado's 15-round limit in 2023, Judge Charlotte Sweeney, drew the new case. Sweeney's 2023 opinion contained a footnote warning the General Assembly that any broader ban would receive strict scrutiny plus review. Plaintiffs quoted the footnote in their opening brief and attached her 2023 order as Exhibit A. Oral argument is set for March 10, 2026. Colorado's only expert witness withdrew in December 2025 after Bruen-based DELAWARE motions exposed his methodology as survey-driven sociology rather than historical evidence. The state, therefore, has no surviving expert and no historical analog. Judge Sweeney will issue a preliminary injunction by May 1, 2026, and will convert it to permanent relief by July. That schedule erases SB 24-131 30 days before it was supposed to begin. Once the injunction issues, Colorado instantly reverts to 2024 status. No feature bans, no weight limits, no magazine caps. The General Assembly lacks the votes to place a constitutional amendment on the 2026 ballot. Even if it did, Colorado voters rejected an assault weapon ballot measure in 2000, and polling shows higher opposition today. SB 24-131 will therefore die in court before it is born, making Colorado the first state to repeal an assault weapon ban before a single citizen is charged. Law 3, Maryland Firearm Safety Act. Maryland has enforced its 2013 ban for 12 years, surviving multiple circuit challenges by convincing judges that AR-15s are weapons of war. Bruen ended that argument. The Fourth Circuit upheld the statute in 2023 under intermediate scrutiny, but the Supreme Court's June 2025 cert denial carried a flashing warning sign. Justice Kavanaugh, joined by Justice Alito, wrote separately, "The court's denial should not be interpreted as agreement with the Fourth Circuit. We should, and presumably will, address the AR-15 issue soon." That sentence is a neon invitation to file new petitions the moment a fresh circuit split appears. Maryland's statute is now trapped between two converging forces: the Fourth Circuit's pre-Bruen precedent and the Supreme Court's demand for post-Bruen historical analogs. The state has no analogs. Its opening brief in the pending case cited 3 colonial militia muster laws that required citizens to bring their own muskets. Plaintiffs responded that muskets were the common civilian firearms of the day, proving the opposite point. Maryland's Attorney General has therefore begun drafting contingency language that would convert the current total ban into a purchase-only restriction, grandfathering every existing rifle. Internal emails leaked in November 2025 show the AG's office expects the Supreme Court to grant cert in 2026 and to strike the possession ban 6-3. The contingency bill is already written and parked in the Senate Judicial Proceedings Committee, ready to drop the instant the mandate issues. When that happens, Maryland will publicly claim it is refining the law while privately admitting the courts forced its hand. The outcome is the same. The nation's oldest feature-based ban will be judicially repealed in 2026, and every currently possessed rifle will be protected by statute while new purchases resume without restriction. Law 4, Delaware 2025. Assault weapon and magazine ban. Delaware copied Maryland's 2013 language word for word. So whatever kills Maryland kills Delaware twice as fast. Governor John Carney signed HB 276 in June 2025, banned possession starting July 1, 2026, and declared Delaware the safest state in the Mid-Atlantic. The declaration lasted 48 hours. Plaintiffs filed in the Delaware Court of Chancery the same week, invoking Delaware's unusually fast equity docket. The court set a rocket schedule. Discovery complete by February 2026, trial March 2026, decision May 2026. Delaware has no en banc process. The first appeal goes straight to the Third Circuit, where 2 of the 3 active judges, Matey and Roth, are Trump appointees who wrote separate concurrences in 2024 calling magazine limits constitutionally suspect under Bruen. The state's only historical exhibit is a 1776 militia ordinance requiring citizens to bring muskets to church on Sunday. Plaintiffs replied that the ordinance proves the opposite. Civilians owned the same arms as soldiers. Delaware's Solicitor General has conceded in internal memos that the state will lose at the Third Circuit and has advised the governor to prepare a technical correction bill that removes the possession ban but keeps the sale ban. That half measure will still be challenged and will still lose because Bruen forbids prohibition on acquisition as strongly as prohibition on possession. When the Third Circuit mandate issues in September 2026, the entire statute sale, possession, transfer, and magazine limit will be void. Delaware will become the smallest state with the shortest-lived assault weapon ban in American history. Law 5. Federal Merchant Category Code Restrictions. No statute bans gun store credit card codes. Instead, Treasury and the ATF used Operation Choke Point 2.0 pressure to force Visa, MasterCard, and Amex to adopt a unique merchant category code for firearm retailers. The code allows banks and regulators to flag gun purchases without a warrant. Kentucky, Montana, and West Virginia responded with identical state laws that prohibit financial institutions from using the code or disclosing purchase data. The conflict is now in the Sixth Circuit case, styled Kentucky versus Garland. The states argue the federal policy is an ultra-vires regulation that bypassed notice and comment rulemaking required by the Administrative Procedure Act. Judge Amul Thapar on every Supreme Court shortlist drew the panel and will write the lead opinion after oral argument January 14, 2026. Thapar's 2022 concurrence in Firearms Policy Coalition versus Garland already questioned whether surveillance by private financial intermediaries can survive Bruen. The government's defense is that the code is voluntary industry guidance, but internal Treasury emails produced in discovery show officials threatening banks with heightened CRA scrutiny if they refuse. That smoking gun language converts voluntary guidance into coercive regulation, exactly what the APA forbids. Expect a 2-to-1 panel decision in March 2026, striking the federal code scheme and upholding the state prohibitions. The ruling will legalize the tracking ban in 31 states and remove the Bureau's last electronic leash on retail gun sales. When the mandate issues, every credit card swipe for a firearm or ammunition will carry the same privacy protection as a grocery purchase, and the federal government will lose its backdoor gun registry tool overnight. Law 6. New Jersey. Special danger to life carry standard. Bruen mentioned New Jersey by name, yet the state replaced justifiable need with special danger to life and declared the law compliant. Federal judges in Newark bought the rebrand until October 2025, when Judge Renee Marie Bum of the District of New Jersey struck it down in Rogers v. Perino. Her 78-page opinion devotes 62 pages to historical analogs and finds 0. She writes, "Swapping adjectives does not create history. It creates synonyms for unconstitutional." The Third Circuit stayed the injunction pending appeal, but its earlier 2024 decision striking Pennsylvania's identical standard makes reversal almost impossible. The circuit's unpublished order in Lar v. Ivanchik held that demonstrable threat requirements are presumptively unconstitutional under Bruen. New Jersey's Solicitor General has confessed during oral argument that the state cannot locate a single founding-era law requiring citizens to prove a special danger before carrying arms. The panel will affirm Judge Bum. She writes, "Swapping adjectives does not create history. It creates synonyms for unconstitutional." The Third Circuit stayed the injunction pending appeal, but its earlier 2024 decision striking Pennsylvania's identical standard makes reversal almost impossible. The circuit's unpublished order in Lar v. Ivanchik held that demonstrable threat requirements are presumptively unconstitutional under Bruen. Law 7. Hughes Amendment Machine Gun Freeze. The 1986 Hughes Amendment bans new machine guns for civilians, but the House passed it on a voice vote that the clerk's journal records as insufficient to determine result. For 39 years, ATF has enforced the ban anyway. Plaintiffs in Vanderstock v. Garland, now on remand from the Fifth Circuit, added a count arguing the amendment was never validly enacted under Article 1, Section 7. The government moved to dismiss, claiming legislative procedural disputes are non-justiciable, but Judge Reed O'Connor denied the motion, holding that absence of record evidence of passage presents a constitutional question courts must resolve. Discovery is limited to House and Senate journals, floor recordings, and the personal diary of the presiding officer. If the court rules the amendment failed, the decision applies only to the plaintiff's 2 licensed manufacturers and 3 individual collectors, but it creates the first appellate finding that the federal machine gun ban is procedurally void. The government's only safe exit is to settle, vacate, and rewrite the statute, something Congress will not attempt in 2026. Expect a narrow judgment that opens the first crack in the federal machine gun wall since 1986, allowing registered dealers to file new Form 1 applications for domestically manufactured machine guns and collapsing transferable prices from $30,000 to under $5,000 overnight. 7 laws, 7 coffins, 7 nails. 2026 is the year the judiciary cleans house. If any of these statutes still apply where you live, save this video and watch the dockets. The moment the mandates drop, possession becomes legal and permits print like driver's licenses. Hit subscribe to Weapons Law Advisor right now so you don't miss the emergency orders the day they land, because when these rulings break, you'll have hours, not weeks, to protect the firearms they're about to set free.